Court calls the case. People versus Amanda Smith.
After Lonnie for the people.
Just on behalf of Amanda Smith. Amanda, would you state your name for the record?
Amanda Smith.
Judge, today's time day for PCC. My client is going to take advantage of the offer offered by Miss Londe to plead to a no.
I have a plea form that indicates she's going to plead larceny 200 to 1,000 to 1 year offense. Upon her successful plea to that charge, no contest plea to that charge, count one would be dismissed.
That's correct, Your
There
Honor.
is also an indication of no delayed or deferred.
For the record, Judge, my client is on probation in Detroit, Third Circuit, but this case had preceded that case, so I don't believe there'd be a violation of that. We've signed a vice of rights, and I don't know if the judge sentencing waiver was necessary, but we signed it.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Amanda Smith.
Smith, it is this court's understanding that you are going to be pleading no contest to the charge of larceny 200 to 1,000. Is that correct? That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. Two things about it. I have to make sure you understand it. First means that you're not further desirous or wanting to contest these charges. You understand that?
Sure.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Basis for the no contest plea?
A potential civil liability, Your Honor.
All right, ma'am. To this charge, how do you plead?
Contest, Your Honor.
You understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
Yes, sir.
Look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading, you're giving up those rights as well as all the rights on that form. Yes? You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Yes.
Pardon?
Yes.
You are, but this offense
Happened way before.
way before you were placed on
Yes.
probation. All right. Has anybody promised you anything other than what's been stated here today to get you to plead? Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will.
Yes, sir.
Court has been handed and has reviewed Washington County Sheriff's Office report for their case number 22007121. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 13th at 10 a.m. before Judge Washington.
February 13th, 2025, 10 a.m. before Judge Washington. Bond continued.
Thank you, Your Honor. I will instruct my client to contact probation department 14B.
All right.
Judge, may I have police report back?
Do what you gotta do.
Judge, I thought you'd be in a little better mood tomorrow.
I am in a fine mood. Thank you, Mr. Killowald. You just keep trying to spoil it. Get him out of my well.
I'm trying.
Just give him his little papers back. Go. Just go. Is that your last day?
Yes, I'm out of here.
Okay, good. Now I'll be in a great mood.
Happy New Year, Judge.
And to you, Mr. Killowald. Oh no, but Pellinger's gonna come up. He's gonna just.
I would love one of my kisses to be called Your Honor. That'd be great.
Put it at the bottom.
Oh, come on.
Court calls the case, People versus Thomas Rastall. Yeah, I know what you're trying to say.
After Lonnie for the people.
Your Honor, Alexis Pluma, Assistant Public Defender, appearing with and on behalf of Mr. Rastall, who is approaching. Could you state your name?
Thomas, right?
Thank you, sir.
And,
You're requesting an adjournment?
yes, Your Honor, we are requesting an adjournment, of about 2 weeks. We're still waiting for, Mr. Rastall's screening to be completed with the Washtenaw County Treatment Court out of 14A4. It's been 3 weeks since he was referred, so I'm hoping an additional 2 weeks, it'll be done by then.
Which court?
It's Judge Freshour's treatment court. I think it's called Washtenaw County Treatment Court.
Okay.
And Your Honor,
You think too? Okay.
I would like to address bond if I could.
Of course you would.
So, Your Honor,
You do adjourn it, or you want to address bond, or you just want to keep talking?
can we do both?
Whatever you want to do. Go ahead.
Okay, so why don't we get the new date and then,
Okay, let's do that. Boy, she is
I'm sorry, Your Honor.
awful bossy. Probable cause conference.
Ask him.
You think 2 weeks will be enough time?
I'm in 5 weeks to get the screening done. I hope that would be,
I don't know what the holdup would be. Let's try to be, let me give you, I'll give you the 16. See where we're at.
okay.
9 a.m. Yes, as to bond.
Your Honor, with regards to bond, I am asking the court to consider a personal bond for Mr. Rastall. His bond was revoked 3 weeks ago on December 12th for a bond violation for a positive drug test. At that hearing, Mr. Rastall took accountability for that. He came to court knowing that it was incredibly likely that he would be remanded. He's expressed to me a genuine interest in treatment court, and in his sobriety going forward. He has reliable.
Counsel,
Yep.
if I were to let him out, what would be in place that would allow his sobriety to happen?
Your Honor, he would be doing the screening for treatment court. He doesn't have treatment set up, but what I was going to mention was that the reason he's requesting to be out in part is because he was scheduled for a major dental procedure on the 13th. He's afraid that if he misses that appointment, he'll lose the funding for it. He was due to have many teeth extracted and get fitted with dentures. That's something that's causing him a lot of pain. And he also states that he hasn't had access to all of his medications for his glaucoma while he's in the jail. So he would really like to get home. He has his own apartment. He's got reliable transportation, reliable contact information. He could do the screening out of custody. I understand the court's concern with regards to not having treatment set up yet, but again, just asking the court to consider a personal bond.
We already
Rastall
did
is-
that though, didn't we?
Yes.
And that didn't work too well.
Yeah.
Response?
Your Honor, we were here on the 12th and defense counsel asked for early screening at that time and the court wanted the defendant to be screened first. And I think that makes a lot of sense. Unfortunately, with the variety of substances, don't know that we can have testing conditions sufficient to ensure public safety and people's minds. I would say that when Mr. Rastall is screened by Mr. Peterson, which I think I'm surprised it's not already been done, frankly, because he's very quick, especially when he knows people are in custody, which you did know at the last time you were here, I believe, if I recall correctly. If he screens Mr. Rastall and then want to get a stipend order together for residential treatment or inpatient treatment, the people would be very happy to consider at that time a stipulation.
I'm trying to get outpatient.
All right.
Understood, Your Honor.
All right. So motion for bond reductions tonight. Bond will continue. Thank you. Court calls case People versus Thomas Elkins.
Mr. Lundy for the people.
Assistant Public Defender, Chanel Kelly, I can remember, Your Honor, on behalf of Mr. Thomas Elkins, but unfortunately not for Mr. Elkins, Your Honor.
Oh, boy. Here we go again.
First one for the year.
Yeah, but it's just a continuation of the same process, isn't it, in a second?
For different. But Your Honor, it looks like Mr. Elkins was originally in custody and he's no longer in the Washington County Jail. I have not been able to make any contact with him.
We'll solve that.
I would be remiss if I do not request an adjournment, possibly, you know, being released and navigate the court system. It's a little difficult.
It does look like the defendant was arraigned on Christmas Day and he got a PR with a scram tether before release. So
He took his scram and ran.
I see. So I'm going to request the bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 25,000. Cash surety. That warrant will issue immediately. Second ruling. It's just gonna be a long year for her. Court calls the case, People versus Jerry Relaford.
Andrew Childers appearing on behalf of you.
Assistant Public Defender Alexis Plea appearing with and on behalf of Mr. Relaford. Mr. Relaford, could you state your full name?
Jerry Relaford.
And Your Honor, at this time, I believe our office is still waiting on video discovery on this file. So we would ask for a very brief adjournment.
January 16th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you.
Corsia Harris.
Ashley Lonnie for the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Harris.
Is this the one you want to?
I know.
No, is this the one you want to call?
Listen.
Is this the one you were in a rush to have called? You don't even have a client. Go ahead, Bellinger.
I knew I was.
He was rushing to have, you know, you see,
I do.
did you see that? This
Your
is
Honor.
how he starts the year off. I had to like pass it and make him sit down and just wait. Like waiting for his client. But I'm not gonna do that to you.
I appreciate.
I am in a New Year's spirit.
I would ask, and see, I'm not Bob Killawald, and I'm not
Wow.
going to try to put you in a mood.
I know Mr. Killawald. Mr. Killawald's a good friend of mine. You are no Bob Killawald. Go ahead.
Your Honor, I have spoken with Ms. Harris this morning. She informed me that she was in the drug treatment court this morning. And/or I have a text message from her, Your Honor.
Uh-huh.
And that says, "Good morning. I am in treatment with Don Farms." She was asking if it was possible for an adjournment this morning on her behalf. I did inform her of the violation. I wasn't aware she was in treatment with Don Farms, Your Honor. I did tell her that she needed to appear because of the violation. I did also talk to her. Go.
Don Farms will usually arrange to get him here.
Yeah, I understand, Your Honor. I think that because she probably did it this morning, because this is the first I'm hearing about. I talked to her yesterday and she wasn't doing that. She was working with Sparrow only. She may have just admitted herself inpatient in Don Farms. So I don't believe she's going to be appearing today. I would ask for an adjournment. Thank you. The end.
It was the end before you started.
Oh,
go ahead, Ms. Lundy.
We would request bench warrant given her community corrections violations for not going and not testing and out of here.
New Year spirit.
Okay, well, here it is. Bench warrant, $25,000 cash surety. That warrant will issue immediately. Thank you.
Thank you. Great seeing you, Your Honor.
Yeah. Yeah, a little bit more sincerity in your voice. Is that all that you have?
No. Do you want to call my other one so I can get out of your hair? I know
I know, Miss Apple, he's lost his mind. I don't know. Ms. Apple, you know how to conduct yourself. Talk to him.
Oh,
All right, thank you. Court does call the case of the people versus Walter Peterson.
Kyle Bradell on behalf of Mr. Peterson, but not with. I have been in contact with him this morning, Judge. Much like the rest of us, I know myself, certainly he has lost track of the date. What it was, I told him Thursday, and I don't have something with myself. So I'm just asking that the court pass the matter. I did call him today. He's on his way.
Bench warrant will issue, bond 10,000 cash surety, warrant will issue immediately.
Thank you, Judge.
Court calls the case of the people versus Brianna Kingsley.
On behalf of the people. Assistant Public Defender Jay Bellinger on behalf of Ms. Kingsley, who coaches, Your Honor. Ms. Kingsley, can you please state your name for the record?
Brianna Kingsley.
Your Honor, I have submitted an adjournment form to the court. We have some continued negotiations. I did send a mitigation report for review by the prosecution. They're asking for, her next pretrial is set for February 25th? 12th. I understand that the court can't go out that far. I do.
Well, that's in 15.
Correct.
But as I'm reading this, you're trying to track that case.
We are trying to track the cases together too, just to see what's going on in terms of mental health treatment, Your Honor.
Okay. Back up a second.
Sure.
Haven't seen Miss Kingsley for a while. Is she in mental health court there?
She is not. She is getting mental health treatment, however, outside of the court.
Got it. And so that's, correct me if I'm wrong, that's being monitored kind of with the 15th District Court case.
That is my understanding.
And you're trying to follow along with some of that information regarding this case.
That's correct, Your Honor.
So why wouldn't I put it out after?
I would be asking for you to. I just didn't know if the court would be willing to do that for me.
You know, Bellinger, sometimes you just have to ask, but you always just ask for the wrong stuff.
Oh,
All right, this one I would do. This is not a problem. All right, so
Then we're asking.
okay.
what?
Then we're asking.
She got
Well,
this.
I know Mr. Kingsley would ask me. I just don't know why you didn't.
I was trying. I was going to get there.
Well, quit taking the scenic route. So your next date in 15th is the 12th?
Yes, sir.
All right. So let's go then, so you can figure that out. I won't go to the next date. Let's go to February 20th, given those circumstances.
Thank you, Your Honor.
February 20th, 2025, 9 a.m.
Okay. There you go.
I'll do that for Miss Kingsley.
Thank you.
Right?
Thank you.
Yes.
Thank you.
Happy New Year. Court calls the case, People versus Eric Mayfield.
Your Honor, Alexis Plea, Assistant Public Defender, appearing with and on behalf of Mr. Mayfield. Mr. Mayfield, could you say your full name? Your Honor, we are asking for an adjournment here. I would just ask for 2 weeks.
Without objection, January 16, 2025, 9 a.m. bond continue.
Thank you, Your Honor.
Court calls the case of the People versus Antoine Patterson.
Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson, Antoine Patterson. Your Honor, I have done everything to try to get a hold of my client, less a carrier pigeon. I have not been able to do so, unfortunately. I have reached out to prosecution in order to try and get an offer on this case. Still haven't heard from my client. That being said, I would ask for an adjournment. Am I asking for the wrong thing again?
We would object to that.
No, you're asking for the right thing. Just denied. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash here.
Can we make it 10?
You want me to add 10?
No,
Okay.
less 15.
That warrant will enter me. Thank you.
Thank you. Have a good day.
Are you done?
I am.
Bye.
Welcome.
Wait till he leaves the room. Court does call the case, People versus Levante, Washington.
That's a lot of people.
So Public Defender Natalie Pate with and on behalf of Washington, who is approaching the podium. Please state your name for the record, sir.
Levante Washington.
Thank you, sir.
Thank you, Your Honor. As to the probable cause conference, we are respectfully requesting a very brief adjournment. And we do understand that Mr. Washington was asked to be in person today because of the progress report that was sent out. And we also willing to address that one, whoever the court would like.
Why don't you go ahead and address that?
So as the court is aware, Community Corrections did send out a progress report. Mr. Washington did test positive on both 12/27 and 12/30 for cocaine. He did already send out the 12/27 sample to the lab for confirmation. We have not yet received the results from the lab one way or another. He does plan on, after court today, appearing in Community Corrections to have his most recent test sent out for confirmation from the lab. He had planned on doing that today in any event. However, as to the progress report, we're asking the court to hold it in abeyance until we get those lab confirmations back, whether or not that was a positive test. Mr. Washington does deny any use. He is here today with his mother, who I have also had the opportunity to speak with. He resides with his mother, and his mother also says she doesn't know him using. Of course, she's not with him all the time. However, Mr. Washington does deny use. That's why he sent it out to the lab. So we're just asking the court to hold this in abeyance until we get that confirmation one way or another.
And then if it comes back positive, what do you think I should do?
I would ask that that be addressed at that time.
So you just don't want me to lock him up today?
Certainly not today, Your Honor. Mr. Washington appeared knowing that that was quite frankly a possibility. He's staying on top of this, continued to test even after he did get that positive result, went to Community Corrections and paid the $30 to have that sent out.
You going to have a test today?
Yes, he's appearing. He is going to go to Community Corrections after court today to have his test from the 30th sent out, and I believe also to be tested again.
Why do I have the feeling I'm not being told the truth? I've got 2 tests back to back with cocaine. So let me ask this question. If I send you over today and I get those results immediately, is anything going to show up in your system?
No, Your Honor.
Pardon?
No, Your Honor. Like I say, I got a lot of stuff going on for myself. This is not the only. This is probably the least case that I'm worried about. I'm on GPS tether. I don't have no reason to run or no reason to not show up and come back to court.
That's all fine. I'm more worried about your use at this point.
Oh no, I don't use at all. I'm not trying to pit everything out on the line. If we can speak privately, then I'll be able to tell you exactly what's going on, but I don't want to pit everybody on Front Street. That's it, in the courtroom.
So, did you read over that progress report?
Me?
Yeah, because I'm getting a lot of people that are amoebas.
Yes, I did read over the progress.
They're absorbing cocaine. And I'm not sure how that happens. Young lady appears at Community Corrections, said, I smoked it around him. That must be how he's testing positive. You believe that? You believe, hold on, no. You believe that?
Yes, Your Honor.
Really?
That's the truth. I got
Council
too much on the line.
Pro, you know, you might want to just be quiet because the thing I don't like a lot are people that aren't telling me the truth. Because you can go play your game anyplace else. You're not playing it here with me. Council approach. Please send that. Anything else you want to say?
Nothing.
Yeah, I'll give him one shot. You want to tell me? I mean, from what I understand, he comes over from another place. He's in our jail, gets out, and is saying he wasn't using. I got 2 tests.
I understand that, Your Honor. I would just reiterate my request to hold this in abeyance until the lab confirmation comes back one way or another, and to address it at that time. If in fact the lab confirms that it was a positive result, I would ask for that, Your Honor, and I have nothing further to add. But except that Mr. Washington, I do truly believe will be in attendance to its next future court
I'm
date.
not so much worried about his attendance. I'm worried about his using and then lying to me. That's what I'm worried about. And then getting other people wrapped up lying. You're not an amoeba. It's not going to be in your system for 6 days, at least, in this way. Anything else?
Nothing further from me, Your Honor.
I'll grant the adjournment, and maybe, you know, I would have normally, under most circumstances, put it out 2 weeks, but I'll put it out 1 week to the 9th, 2025, 9 a.m. At this point, however, the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Court does call the case of People versus Daniel Magoo.
Actually, let me.
Danny Magoo.
Ready for preliminary examination, or at least to deal with his motions? What are we doing?
Yeah, would the court be so kind as to make the self-representation inquiry? And
Yes.
perhaps we could look at the motion first.
Mr. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings, you decide that you wish to be represented by counsel, cannot afford to hire counsel, then an attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you.
What are we doing?
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do, Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his, I will note, I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more of a difficult time with some of the audio files that come from my office, so that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of,
I believe it's the 911 call that brought the officers to the scene, but it would not be an exhibit that people plan on playing at the preliminary examination.
all right.
I would like then to motion for a preliminary examination to get the officers in here on the record, then, Your Honor, please.
All right. Is there anything else you needed the court to deal with? You mentioned bond conditions. You say you have all of the discovery. There may be an issue with the playing of this one audio. Is that correct?
That's correct.
Anything else you're requesting?
No, Your Honor.
All right.
At this time.
With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. So the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate. Does not see an abuse of discretion regarding that. With reference to the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter and would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Fine for Your Honor.
Yes. So preliminary examination will be set January 21st, 2025, 9 a.m. before me. That's in person. Attendance bond with conditions is continued.
Thank you.
What we just witnessed is a powerful reminder that the courtroom isn't a place for excuses or half-truths. When a judge starts questioning credibility, everything changes because the entire case can hinge on trust. In simple terms, if the court believes you're not being honest, your situation can go from bad to much worse in seconds. And that's exactly what happened here. The law isn't just about facts, it's also about accountability. So the real question is, was this a misunderstanding? Or did the defendant push their luck too far?